Good afternoon, everyone, and good morning to those of you who are not on the Eastern Time Zone. I'm Daniel Markind. I'm the head of the Flaster Greenberg Aviation Group, and I'm here with my fellow aviation colleagues, Marty Judge, Megan Moore, and Lauren Schwimmer. For the next hour and a half, we're going to talk to you about aviation, airports, and insurance, and specifically the roles that insurance will play in the recovery of the airport industry and further in the life of airports themselves. Now, there are a number of you interested in this topic, so I imagine there will be a lot of questions that are being asked throughout the presentation. We have designated time after our presentation to answer your questions. To ask a question, simply click on the chat feature at the bottom of your screen to send a question to our panelists. We will do our best to answer all the questions within the allotted 90 minutes of this seminar, of this webinar. Now, since we're lawyers, if we could have the next slide, we need to give our disclaimers. Therefore, we need to include in the slide deck that the information contained in this webinar is not legal advice. Secondly, this webinar has been approved for 1.5 CLE credits in Pennsylvania. So for those of you who are Pennsylvania attorneys and wish it, please email your name and PA bar ID number to marketing@flastergreenberg.com. Also, due to the complexity of the topic, we are currently recording this webinar so that our attendees are easily able to revert back to any PowerPoint slide that's not covered in its entirety. Our marketing department will send you a link to the webinar as soon as it's live on our firm's COVID-19 resource page. Next slide, please. I'd like you to meet Flaster Greenberg's National Aviation Law team. From left to right, Kelly Barry, Marty Judge will be on the presentation, myself, Megan will be on the presentation, Frank Riesenberger, and Lauren Schwimmer, who also will be on the presentation. Now, our panel will collectively remove our videos so that only the speaker is visible during their portion of the presentation. At this point, I'd like to introduce my partner, Marty Judge. Marty is one of the true experts in the fields of both of aviation and the relationship with environmental law. He's been an environmental lawyer for more years than he wishes to admit. And what he's going to do is give you first a little bit of an environmental law background sort of update, and then introduce the insurance aspects of it. So Marty, please, the floor is yours.
Thank you, Dan. And hello, everybody. In thinking about this presentation before we actually put it all together, it occurred to me that we're really in, and can I have the next slide, please? That we're really in a new paradigm situation where we have two unprecedented areas of airport liability exposure that are coming together at once to create potential new insurance issues. At first, we have the COVID-19 situation, and then the second issue, which we've talked about in prior webinars, is the PFAS issue, or per and polyfluoroalkyl substances. And I think everybody on this webinar probably is aware the PFAS situation mostly comes to light in airports because of the use of a particular type of AFFF foam for firefighting that contains these substances. So in analyzing broadly the types of claims that might be at issue, they're a little different between the two situations. For COVID-19, you have this ubiquitous presence of a virus that's in the environment. And as far as airports are concerned, it basically leads to two issues: third-party personal injury claims against airports due to human exposure, and potential airport first-party losses and therefore claims from required compliance with the antiviral governmental directives. As far as PFAS is concerned, it's a bit of a broader issue. You have environmental releases of FAA-mandated PFAS containing AFFF that's used for firefighting, and that leads to third-party personal injury and property damage claims for human and environmental exposure, and also airport first-party losses from required compliance with governmentally directed cleanup directives. Next slide, please. So I will focus at present more on the PFAS issues than the COVID issues, but I'll try to tie it together a little bit at the end from an insurance perspective. COVID will be more specifically discussed by my colleagues, Megan and Lauren. Next slide, please. So I want to talk a little bit about airport-related PFAS litigation to date. In terms of what may involve airports, there have likely been many more lawsuits that have been filed involving PFAS than regards to coronavirus to date. Looking out at the universe of these types of PFAS lawsuits that have been filed literally all over the nation, it's pretty clear that right now airports have been parties in only a handful of these things so far, and that's mostly due to their FAA mandated use of AFFF foam. But the list of PFAS related lawsuits generally is growing very rapidly. Therefore, we predict that it's only a matter of time before a substantial number of airports really do find themselves in one or more of these lawsuits, whether they choose to be there or not. And the same holds true for governmentally mandated cleanups, which are not technically lawsuits themselves, but often originate from things like administrative directives or administrative orders or that sort of thing that might be issued by a state authority or even the federal government. Next slide, please. So, to repeat, we are uncertain whether a Part 139 airport anywhere has actually been sued yet for mere AFFF usage or to compel cleanup, but it is certainly coming if it has not happened already. For an example, there was a recent case, two cases actually, brought against the Navy, who was sued by residents living near to the former Willow Grove Naval Air Station in eastern Pennsylvania for allegedly contaminating their drinking water. So that was a situation where the airport, obviously the successor being the Navy, was directly sued, made a defendant in a lawsuit seeking costs for cleanup and other damages. The case was only dismissed because it had to be shown by the plaintiffs that the PFAS was a hazardous substance under state law, and that had not yet happened. However, as the last bullet point reflects, in New Jersey actually has administratively changed its code to declare that PFOS, PFOA, and PFNA are hazardous substances in New Jersey. So the issue that caused the dismissal of the Navy in the Pennsylvania suit would not be an issue in a similar suit in New Jersey if an airport were to be sued there. And the same is true literally in every other state in the nation. Next slide, please. So what are some of the examples of the different types of PFAS-related lawsuits that have been filed around the country and that could also affect airports? We found an interesting summary of these lawsuits online, and after fact-checking to make sure that the summary was correct, we put together this list of the types of lawsuits that typically involve PFAS. You have federal multi-district litigation alleging products liability claims, class action claims for contamination, water utility claims, actions that are brought by state governments, and then other types of litigations. I'll briefly go through them and point out to you where the airports may come into being. So there is in the federal lawsuit system something called multi-district jurisdiction, where you can have lawsuits that are filed all over the nation and then they get consolidated before a single judge someplace for handling those lawsuits, mostly for discovery and what we call motion practice, but also potentially ultimately for trials. And it happens that there's a federal judge in South Carolina who has been handed pretty much all of the product liability claims that have been brought by anybody relating to PFAS and PFAS exposure anywhere in a federal court in the nation. And so the typical type of a claim is somehow that the product itself, whether it's either straight PFAS, chemicals, or AFFF foam, some of the suits deal with one versus the other, the product itself is dangerous or is defective. And therefore, in these types of lawsuits, there are claims seeking damages for that. There are literally hundreds of these cases that have been consolidated in South Carolina, possibly over 1,000. I didn't count, but there are very many of them. What has recently been happening is that some airports themselves have been availing themselves to the opportunity to bring these suits. And so you have some cases where airports are plaintiffs, they're not defendants, and they have been suing the same manufacturers as everybody else for similar types of damage. One case in particular, although there are a handful so far of airport cases, and the list is growing, one case in particular is the Hillsborough County Aviation Authority versus Tyco Fire Products LP case. I'll send us a request and I'll give you the docket number. And in that case, the demand is that the airport is seeking, quote, all past and future compensatory and or consequential damages for the investigation, remediation, removal, disposal, and monitoring of the ongoing contamination of its surface water, groundwater, soil, and sediment caused and or created by defendants at AFFF foam. That's a mouthful, but that's what they're suing for. And the other cases are similar. Next, hold this slide. I've got a few more things to say. So on class action claims for contamination, these suits have been brought in Vermont, Michigan, North Carolina, and New York that we know of so far. There may still be others. And typically, it's a lawsuit brought against a discharger or a company that used and manufactured either PFAS chemicals or products that use those chemicals, like AFFF foam, where in most of these cases, if not all of them, it's groundwater contamination that's at issue. So you have a series of homeowners living nearby who have wells. They've been contaminated by this discharge or this release, and a class action claim has been brought. So far, we haven't been able to identify any of these cases that are class action claims against airports yet, although the Navy cases I referred to earlier could have been styled as class action. But again, it's probably only a matter of time before airports find themselves in this situation. Water utilities claims are interesting because water utilities have to deliver clean and fresh water as part of their mandate as licensed utilities. And when they find that their water supplies, either in groundwater or surface water, have been contaminated, they are increasingly bringing claims. So far, again, we haven't seen situations where water utilities have sued airports directly, but what we have seen are situations where the utilities bring claims somewhat similar to the products liability claim I talked about earlier, but slight variant on it. And they're suing the manufacturers of PFAS chemicals, typically somebody like 3M or DuPont or Tyco or somebody like that. And we have seen some indirect airport involvement in these lawsuits. What we've seen is subpoenas have been issued, usually by the defendants, somebody like 3M, to local and nearby airports, asking them to produce, as part of their obligation under the federal rules, to produce information and records relating to their past usage, storage, and any discharges or releases of AFFF foam on their premises. We don't quite understand yet what the strategy is for issuing these subpoenas, but it may be something like the following. There's an attempt by the manufacturer to dilute its liability by attempting to show that there have been releases of these products elsewhere, and that therefore, if the manufacturer bears any liability, then the parties responsible for the releases have also done so. State broad actions typically are for natural resource damages, and typically against the manufacturers themselves. These have been brought in a number of states. Again, we haven't seen airports yet brought in, but it seems only a matter of time. And finally, other litigations, I'll skip that because I'm running out of time, but that is not an area yet where we've seen airport involvement. Um, so in looking for the types of insurance policies, let's say an airport is being sued or has been there's been a threat that it be sued, and looking for the types of insurance policies that an airport should look for, we've identified several that typically an airport might have. The first are general liability insurance policies. I think everybody understands what these are. These are business insurance policies that protect against a variety of different types of risks. They've been around forever. There's a variant on that called aviation general liability insurance. It's basically a GL or a CGL policy that's got some additional coverage in it for airport specific things, not related to PFAS specifically, but for other things. But so they're really lumped in the first category. And then pollution liability insurance. I'm going to talk a little bit in next about exclusions from coverage for pollution. But you can buy, and it's been a product that's been around for a while now, pollution and liability insurance, where you can, in effect, cover that exclusion by a separate policy that protects you from pollution situations. Some airports have these policies, but probably not most of them. Next slide, please. And then there are specialty insurance products. Typically, these might be something that's issued by a Lloyd's of London syndicate, where somebody went to them asking for specialty insurance, and after evaluating the risk, a syndicate is put together and premium numbers are calculated by the underwriters. There may be unusual policies like this at an airport, so I wouldn't rule it out, but it's probably likely to be only very few. Next slide, please. So we're talking now mostly about general liability insurance policies, GL policies, or what they used to be called CGL policies, and something called the absolute pollution exclusion. And why is this important to potentially current PFAS claims? A little bit of history. In the pre-1986, 1987 era, there were these policies that were then called generally comprehensive general liability insurance policies, or sometimes commercial general liability insurance policies, but they typically contain two magical phrases: sudden and accidental, and expected and intended. And what they really were attempts by the carriers to sort of state what was included in coverage and also what was excluded from coverage. The idea was that the carriers were insuring for any and all liability risks unless they were intended in some way. So if you went out into the backyard and you purposely poured some contaminant onto the ground, then you may not have coverage. That would be an intended result. But if it's just by your normal operations that pollution might have happened, you might qualify for coverage. And so that's what these terms basically mean. They're to be regarded as flip sides of the same coin. It happened that in that pre-86, 87 era, or at least in lawsuits interpreting policies that were issued in that time frame, there were a number of courts that interpreted these policies broadly, and they did find coverage, except in situations where there was an actual intentional pollution. So in reaction, the insurance industry devised something called the absolute pollution exclusion, and it pretty much reads exactly as you guessed. It absolutely excludes any liability by the carrier for any act or event of pollution, regardless of whether it's intentional or not. The courts have generally upheld this exclusion. And so you have this situation where you've got a dichotomy of potentially older policies in the pre-86 to 87 era that may provide coverage for something like spills related to, or even just the discharging on the ground of AFFF foam and the PFAS that comes with it. You may have that under the older policies, and it's almost certainly going to be excluded under the current policies. So what does this mean? Well, since most CGL or GL policies are occurrence-based policies and not claims-made policies, again, two insurance terms of art, if it can be shown that an old spill or release occurred during a pre-absolute pollution exclusion policy time period, you may actually have coverage because these policies don't go away. That's the essence of an occurrence policy. It ensures off into the future for, unless there's an exclusion date, sometimes there is, it insures off into the future for risks if the occurrence, the act of pollution occurred a long time ago, which often is the case with AFFF foam. Next slide, please. So there's some practical advice here that we take away from this. Never, ever throw out your old insurance policies. No matter what your records retention policy may be, no matter whether the general counsel thinks it's a good idea to clean out that cabinet, don't do it. Keep the policies. Treat them like gold because that's literally what they are. In fact, our advice is always to put them in a really safe place, like a fireproof or a theft-proof safe or something like that. Also, retain all the accompanying documents, all the correspondence with your broker, for example, as these may be useful in a situation where you have a lost policy. I'm going to talk about that in a minute. So now also make duplicates of your old policies. Scan them, turn them into PDFs, but also keep photocopies of them as well. And keep the duplicates in a safe place, maybe not in the same safe place as the original policies. The reason is some carriers will accept duplicates of original policies, but even if they do not, there's something called a lost policy claim that you can bring where you can ask the court with appropriate evidence to declare that you actually did have a policy and whatever the terms and conditions are. In the case that you're pretty sure you had coverage, but you can't find a policy or a duplicate of it, don't give up hope, because you can hire experts called insurance archaeologists who go out and do a lot of digging, who have access to old policies and other means of determining what may have existed. And there have been a number of cases where lost policy claims have been proven by the groundwork laid by insurance archaeologists. And finally, in all cases, work with an experienced insurance claims attorney to obtain coverage. Don't give up, and follow the advice of your coverage claims attorney. Next slide, please. The last thing I want to talk about very briefly is a number of our airports have been asking about the status of a search for a suitable AFFF substitute. Pardon me. And so you've got a couple of competing statutory requirements here that are relevant and have created a somewhat unusual situation at present. You have the 2018 FAA Reauthorization Act, which had a specific provision in it that said that FAA shall not require the use of fluorinated chemicals in AFFF foam after October 2021. So that's less than a year away now. At the same time, you have the more recently enacted 2020 National Defense Authorization Act, which provided that the Department of Defense is required to phase out the use of AFFF foam for firefighting on DoD installations by October 2024, or 3 years later. These different deadlines create problems, not so much for the Department of Defense, but certainly for the FAA and airports who are regulated by them, because currently the FAA requires that all certificated Part 139 airports must use firefighting foams that meet a particular Navy military specification, or mil spec. Now I've listed it there. Next slide, please. So both agencies have actually been working cooperatively to try to find a suitable substitute, and they were well on their way, and there were testings being done at FAA's testing facility in Atlantic City up until about March or so, when the COVID-19 restrictions hit and FAA had to shut down that lab. It stayed shut down all the way through September. They were able to test 5 or so substitute formulations so far. And although they did work in varying degrees, none of them specifically meet the mil-spec standards. So therefore, at the moment, it does not appear that FAA is actually going to be able to meet the October 2021 deadline to fully phase out this foam. And the best available evidence so far suggests that DoD may several years later have to make a decision about whether it will make adjustments to the mil spec, or possibly come up with a new mil spec, or just continue to search for a substitute that meets the mil spec specifications, which seems unlikely. So the takeaway from this is we are advising our airports that you're probably going to continue to have to maintain your existing AFFF supplies and use them until you are specifically advised by FAA to the contrary. Next slide, please. And that's all I had. Thank you very much.
Thank you, Marty. Appreciate it very much. We're going to get much more general now in terms of insurance and bring in Megan Moore. COVID has been a disaster for all of us nationally and around the world. I guess a silver lining for us at Flaster Greenberg is that we've had a lot of really great new attorneys join us during this pandemic. And one of them is we had a great insurance coverage team, which is really doing great work. And Megan is our new shareholder, who is in our Boca Raton office, an expert on this field and a pilot herself. And we're going to turn the floor over to her to talk about, in a much more general way, airports and insurance. So Megan, please take it away.
Thank you, Dan. I appreciate that. And let me just see if I can change my view here. Excellent. As a background, I've been representing policyholders in companies, both companies and individuals, in disputes with their insurance companies for the better part of 2 decades. Now, I have been a pilot also for far less time than that, but I thought it might be more interesting to show you a picture of my little plane at our little local airport as a background, virtual background, rather than my actual background, which is quite dull of my home office. I've been asked to speak to you today about whether and how insurance may play a role in recovery for the airport industry in response to the COVID-19 pandemic. Now, I want to mention one thing, and that is that listening to Marty's presentation, it really reminds me, and it should remind all of us, that insurance comes into play in so many circumstances. And the topic that I'm going to discuss with you today, while incredibly important and timely, is just a sliver of how insurance could be implicated for airlines, airports, and aviation in general. We hope to present a series of webinars over the year that touches on some of the really hot topics, one of which is the climate changes and things of that nature. But today's topic is one that is rapidly evolving in the legal landscape right now. And so the content of what we can cover here is really important, and it's going to fill the time that we have today, so we didn't have time to cover the other topics. Molly, if you could switch slides. All right, this is the roadmap of what we're going to cover today concerning insurance coverage in the wake of the pandemic. We are going to discuss first the impact on airports, the coronavirus impact on airports, and I hope that I can cause you to think about this sort of in a manner that allows you to start thinking about lost revenues and lost income, and how you may be able to seek coverage for those losses. There are 2 primary types of policies that will potentially respond to COVID-19 issues. First are commercial property insurance policies. And we're going to talk about triggers for those policies, such as the physical loss or damage to property. We're going to talk about the different types of coverages that are available. You have business interruption coverages, contingent business interruption, civil authority coverage, and then for those unique circumstances where, for instance, an airport project might have a delay issue or something, you've got builder's risk insurance policies and construction bonds. And of course, there are environmental policies, and often those include language that allows coverage for a virus as a pollution condition. Then we are also going to discuss some of the important exclusions within these policies, and we'll get into some real life examples of how courts are deciding these issues in various states. Then we're going to discuss briefly commercial liability policies. This is an area that's a little bit less developed right now, but what we've seen is sort of an advertising campaign by some law firms, uh, basically saying that they will bring these claims on behalf of individuals against airports. So we know these claims are coming, and I think that we'll discuss the different types of claims that could be made, and we'll discuss common exclusions, and of course, we'll discuss some solutions to those issues, such as workers' compensation. Next slide. So, as you all know, probably even more personally than any of us, COVID-19 has had a tremendous impact on the travel industry and on airports in particular. Some of the nation's busiest airports became almost ghost towns in the wake of the pandemic. There were shuttered concourses, gates and runway closures, just an incredible, significant decline in travel. Airport officials say reducing operations has become a cost-saving measure. And I mention this because there are voluntary choices made in response to situations and circumstances like this to make the effort to save costs and save expenses. Those things are typically not covered events, but they're very important because if you do have a covered event, you have to demonstrate to the insurance company that you have mitigated your loss to the extent that you're able. So it is very important to take those measures as a responsible policyholder. Next slide. We saw throughout the pandemic that there was a temporary suspension of various international flights. That was by government order. So that's important. And you'll see, we'll discuss that a little bit with civil authority coverage. There were no federal bans on domestic travel, but we did see many states issue stay at home or shelter in place orders. And that can also be important to coverage. Anytime you look at issues like this, you need to think in terms of the financial impact on the airport itself. Obviously, there were lower revenues. So if you look at things like simply landing fees or passenger facility charges, all of those revenues were reduced. Next slide. Think about your tenants and your vendors also. Restaurants, shops, and services were closed at many airports. And to the extent that they were able to remain open, there was restricted capacity, restricted hours. There are recreational tenants, flight schools closed entirely, skydiving, things that are just elective, ceased to exist for some period of time. So again, the financial impact of the airport, it depends largely on the contracts that you have with your various tenants. But if any portion of the airport's revenue is derived from revenue from those tenants, that can have a direct financial impact on the airport. Next slide. Now, we also saw some very direct COVID impacts on airports. And this is an example of something that occurred. A TSA screener at Hartsfield-Jackson International Airport tested positive for coronavirus. That resulted in the temporary closure of the international terminal. Now, you can imagine that impact or dealing with that impact. You're not only dealing with an individual at TSA, but every airline employee or airport employee that was within the vicinity of that terminal then is potentially sent home to quarantine. And you have passengers of those international flights that are incoming, or perhaps passengers that need to be outgoing that now need to be either quarantined or rerouted to a different terminal area where they can be serviced. And you may have to have additional employees come in order to staff those areas. So the impact can be more than just disinfecting and cleaning the temporary closed terminal. It can have a real financial impact on an airport. And those are the types of things that may be covered by insurance. Next slide. So one of the most important types of insurance, especially in response to COVID-19, is business interruption insurance. And this typically comes as part of a commercial property insurance policy. It's an add-on, and it's one that you should have and hopefully do have. Business interruption insurance covers lost profits And it also covers continuing normal operating expenses. And what that means is the operating expenses that continue even though the business ceases partially or completely for some period of time. So with my terminal example, with the international terminal closing down, you still have to pay for the lights in that terminal. You still have to pay for the water. Those expenses continue even though you can't use the terminal. Business interruption insurance also covers extra expenses incurred to mitigate or continue operations. So for instance, the fact that you might have to pay additional staff to come in while the staff that cannot be present because of quarantining in order to service switching terminals, switching gates, things like that. Those would be extra expenses you're incurring so that you can continue your normal operations. Next slide. So when is business interruption insurance triggered? Now, typically policies have language that indicates that if there is a physical loss of or damage to property, then you have a covered event. And if you have a business interruption loss as a result of that event, then your business interruption insurance is triggered. Now, I say physical loss may include loss of use, and that's important, and it's very debated right now. It varies by policy language. If you have the physical loss of or damage, that has been interpreted as being more indicative of the fact that a loss of use would be covered, but it changes very much by jurisdiction. In fact, the interpretations and the court opinions have changed even within jurisdictions in various different courts. So it's really important to look at the policy language and to understand your state's laws and how these cases are, how the language is being interpreted by them. A complete shutdown is not required. If you have a physical loss that causes an interruption of your business and it's just a partial shutdown of one area of the airport, just the international terminal, perhaps just international flights, there can be coverage in those circumstances. Business interruption coverage covers business interruption losses during a period of restoration. That's a term of art. Typically, a period of restoration starts when the physical loss event occurs that results in the interruption of business, and it continues until the property has been repaired, restored, or put back into the condition that you can use it again. So that is the period of restoration for which you would be able to submit business interruption losses. Now, for COVID-19, how long is that going to be? I mean, if you have a disinfecting crew on staff and you can deploy them quickly, a number of days, maybe less than a day. If you don't, and you have to retain a company to come in and do this deep clean, the period of time it's going to take you to bring them in and have everything disinfected, deep cleaned, and then put back to a position where it can be used again. And what happens then if you have it reopened, but your revenues don't return to normal right away? You may have extended period of restoration in your policy. And if you do, that covers the period of time from the moment that you reopen after you have restored the property until some set period of time. Typically in the policy, it may be 30 days, it may be 60 days, it could even be longer. But it helps to cover any ramp up or any of those business interruption losses you continue to suffer, even though you are able to reopen. Next slide. Contingent business interruption insurance coverage. This is something that is not standard in policies, but it can be added to policies, and it is an important coverage. It recognizes that your business may be contingent on customers or suppliers, and what it is intended to do is to reimburse your lost profits and your extra expenses that result from an interruption of business at the premises of a customer or supplier. So just consider this, and we'd have to consult a broker to see if this coverage is available to you, or perhaps you have a coverage, and then it would be consulting someone, I guess like a lawyer, to find out whether or not the language in your policy could be interpreted in this manner. But if you have contingent business interruption coverage and your customers are considered the individuals that enter the airport, or passengers that are flying on planes that come to and leave your airport, and you have this contingent business interruption coverage and your customers are ordered to stay home unless they're essential, is that a covered event under your insurance policy? That is something to consider. Typically, contingent business interruption coverage it doesn't start immediately. There's usually something like a time deductible or a period of time. It can be hours, it can be days that you won't be covered. But then, as soon as you meet that threshold, from that point forward, you'll have coverage until the physical loss at the customer or supplier's property ceases to result in business interruption losses for you. Now, I'll tell you, typically this coverage, it responds to things like supplier situations. And I'll give you an example of a case in Florida. It's not an airport case. There hasn't been one that I've seen that deals with contingent business interruption in the context of COVID yet. But there was a case where a distributor of beer and wine had a contract under which it distributed to Disney World. And when COVID-19 resulted in the closure of Disney World, all of the beer in that distributor's warehouse spoiled. That warehouse submitted a claim to its insurance company, and the judge actually agreed that they suffered a physical loss to property. The problem was that it wasn't a result of the closure of their own business. And they didn't have contingent business interruption coverage, so they couldn't seek a loss as a result of the closure of a customer or supplier. So they didn't have the benefit of this coverage, and they certainly could have used it. Next slide. Civil authority coverage. Now, this is probably one of the hottest topics and one of the most important coverages in terms of COVID-19 right now. It typically applies when a civil authority prohibits access to the insured's property due to physical loss or damage to property other than at the insured's premises from a covered cause of loss. So this can be a really tremendously important coverage if you don't have physical loss to your own property, but there is a loss within the vicinity of your establishment that creates a business interruption event for you. Now, these policy terms vary widely, and court interpretations discussing them also vary pretty significantly. But I'm going to talk about a couple of cases that have interpreted the civil authority coverage as well as some of these other coverages. Next slide. It is very important to be mindful of exclusions in policies. In response to the SARS virus, the insurance industry drafted a virus exclusion, and that has been available to insurance companies since at least 2006. Other exclusions, and it doesn't have to be a specific endorsement. I have seen endorsements on policies that are specific to SARS. I have seen, endorsements that are that are very virus specific, or I've seen just exclusions in a policy that has a litany of exclusions, and the word virus is buried somewhere within those. It doesn't necessarily, an exclusion for virus isn't necessarily going to be titled virus exclusion. A lot of them will be titled contamination. There'll be some where you've got a pollution exclusion, and even the word virus doesn't exist, but some courts interpret those exclusions to include virus. So important to look at your policy, make sure the word virus isn't there. And in renewing, I'm sure the insurance industry is going to be prepared to exclude anything COVID-19 going forward, but work with your broker to see if you can get an endorsement that does cover viruses other than those that are known to date, because we never know when another occurrence like this or situation like this could arise. And it would be important for you to have coverage. Also, review all exclusions carefully. Some have exceptions. We're going to talk about one case in which there was a virus exclusion, and it was a Lloyd's policy, and the insured was able to, through their broker, obtain an endorsement that negated all exclusions. Unless they were specifically accepted and the virus exclusion wasn't accepted. So we know at least one carrier was willing to to write that exclusion out of the policy. Next slide. Now, in the last 2 months, I'd say October and November, I have seen more decisions that are meaningful on COVID-19. Now, most of these decisions are in the context of a complaint that's been filed after a claim has been denied and the insurance company files a motion to dismiss. So they're not necessarily merits or substantive decisions, but they are very illuminating in terms of what's going to happen. One decision, however, went further, and that is this North State Deli versus Cincinnati. This is a North Carolina state court decision, and it is one of the most policyholder friendly decisions I've seen. It was basically a judgment on the pleadings in favor of coverage for a group of restaurants in North Carolina. They had direct physical loss language in their policy, and what the court held was direct physical loss exists when business owners and their employees, customers, vendors, suppliers, and others lose the full range of rights and advantages of using or accessing their business property. The court did not require an actual physical loss or property damage at the premises. It found that the plaintiffs were expressly forbidden by government decree from accessing and putting their property to use for the income generating purpose for which the property was insured, and therefore there was coverage. So if you're in North Carolina, this is a really important decision. I haven't seen contrary decisions yet in North Carolina. So I would say that's a great state to pursue coverage in. Next slide. Now, unfortunately, not all states have been as pro policyholder as North Carolina. We've seen a number of decisions in California that have gone the other way. And part of the reason is the decisions concerning interpretations of physical loss and property damage. And under California law, the C-Lane versus Continental case, which was a COVID-19 case, the court found that losses from an inability to use property for in-person dining do not amount to direct physical loss or damage to property. Basically, the courts in California have, many of them cite to this language that physical loss or damage occurs only when property undergoes a distinctive, demonstrable physical alteration. Now, if it was a complete loss of use of the property, such that a permanent loss of use, I have seen exceptions for that in California. But it's been tough. Now, California cases still have civil authority coverage, so it's going to depend on the policy itself. Does the civil authority coverage require direct physical loss? Well, the Mud Pie case addressed this issue, and here it said basically that the policyholder did not need to show physical damage to recover under a direct physical loss provision. So it's contrary, really, to what C-Lane said. But the court held that physical force, under that policy, physical force had to prompt the shutdown order. And in the complaint, the policyholder had alleged simply that the shutdown order was to prevent the spread, not that there was the physical force or there was, virus around the property or anything like that. So that complaint was dismissed. West Coast Hotel Management versus Berkshire Hathaway. This policy, I referenced this because the allegations in the complaint, this complaint was dismissed also, but it was because the policyholder did not allege there was any physical damage to any property within 1 mile. Now, there are examples. There's a great case out in Nevada that just came out on November 30th, and it's not in the presentation even, but it is, I can give you the site. It's JGB Vegas Retail Lessee versus Star Surplus Lines Insurance Company, and I can send it to anyone who requests it. But it is a great way. It tells you how to draft the complaint so that you can make sure that you're alleging property damage in the area that you need to allege it, and it just does a good job, because the Mirage Casino actually had a case of COVID, and JGB are the Grand Bazaar shops, and so they alleged that because of that actual case and their proximity to that case within a mile, that there was a high likelihood that COVID-19 was on its property, and the court felt that they did an excellent job pleading and allowed, ruled in their favor so that the complaint was not dismissed. Now, I've also added in a case here, which was interesting because it talks about is Gregos, the Fine Arts Building versus Travelers. This is a case where a policyholder sought rent. They had lost rent payments because of um, relief orders, government relief orders that the policyholder contended made it impossible for them to collect the rent. And Travelers removed the case to federal court, and the policyholder came back and said, you don't have jurisdiction because we haven't met your $75,000 requirement. In reality, the lost rent was about $6,800 a month. And so the court found that it was too speculative to assume that they would lose rents up to $75,000. But the court also noted that that the rent relief orders did not basically didn't make it voluntary for people not to pay rent. The rent was still owed. So there was some question about whether or not the damages would be provable. But interesting because it's still a California case, and it wasn't a dismissal of the complaint. So there may be a possibility for rent, lost rental income as part of your claim. Next slide. Pennsylvania. Pennsylvania is one of those states in which we've had cases go both ways, and it's generally very fact specific and very policy language specific. This was one that went in favor of the policyholder. Taps and Bourbon on Terrace, a restaurant. In fact, this is the Lloyd's policy where they removed the virus exclusion. Pennsylvania state court denied the insurance company's motion to dismiss COVID-19 business interruption losses. The restaurant owners argued that physical loss is any loss resulting immediately and proximately from an event. They said that physical damage was not required. The court didn't write a full substantive opinion on that, but it did find in favor of the policyholders, at least at the pleading stage. And so this case goes on. Next slide. In contrast to that, we had this case, Brian Handel DMD versus Allstate. Now, importantly, the dental office was not ordered to close. The insured argued that the orders allowed only necessary procedures and thus restricted the insured's use of the property, but the policy itself required physical loss to be the reason for the business income losses. And because the insured was still using his property, it was a bit of an uphill battle. Some of these cases, though, even though they actually are decided on the physical loss language, it's almost an afterthought. This policy in particular had a virus exclusion that there was no way the court was going to find to be ineffective or invalid. And the decision actually said that. It said, even if we didn't, even if we found that he made a colorable argument about physical loss, the virus exclusion plainly excludes all coverage under the policy. So I think a lot of, there is some bad law being made because people with bulletproof virus exclusions are bringing claims, and that's a difficult thing for the rest to handle. But the law has started to shift, I think, towards policyholders recently. So next slide. New York. Now, there are some cases or some states where there haven't been a lot of COVID-19 decisions yet. And in those states, policyholders are drawing on arguments that were made in cases with sort of similar conditions in order to make their physical loss or damage argument. And this case is one that's very notable. It's been discussed in various COVID-19 decisions. Port Authority of New York and New Jersey versus Affiliated FM. In this case, the policy insured against physical loss or damage, and the court basically determined that physical loss exists if release of asbestos fibers results in contamination such that the structure is made uninhabitable, or if there exists an imminent threat of the release of a quantity of asbestos fibers that would cause such a loss of utility. So while the court found that asbestos, just a building that just has asbestos, has not suffered a physical loss, it also found that if the asbestos was released, that is a physical loss, or that if there is an imminent threat of it being released such that it could cause bodily injury and there would be no, you couldn't use the facility, that would constitute a physical loss. Next slide. Now, there was recently a COVID-19 decision in New York, and this is the one I've been able to find is actually a decision on a preliminary injunction application. Social Life Magazine Inc. versus Sentinel Insurance Company. Social Life, they sued their insurance company for business interruption losses after the COVID orders prevented them and their vendors from accessing their property. About a week after they filed their complaint, they applied for a preliminary injunction to try and force their insurance company to pay the cost of publishing the next issue. The court found that basically this was sort of foreshadowing for them, I think, but the court found that COVID-19 likely did not trigger the business interruption coverage because it did not cause direct physical loss or damage to the property. New York requires damage to property. Now, this was appealed by the policyholder, and while it was on appeal, there was a stipulation for dismissal of that appeal that was made by the parties, and the case went away. Now, often in circumstances like that, that means there's a settlement. So perhaps the industry wanted this law to be out there and not to be reversed. So that I wouldn't take this decision as being indicative that New York courts are going to find in favor of in insurance companies in general. I think it's still up for grabs in New York. Next. Now, there was an important civil authority case that arose out of the 9/11 terrorist attacks. And I raise this because of the fact that there were COVID-19, we had actual flights grounded in a way. I mean, basically you had a government order saying that certain international flights were not permitted. Well, in U.S. Airways versus Commonwealth Insurance Company, U.S. Airways sought to recover business interruption losses due to the closure of Reagan National Airport following 9/11. And the court held that since the orders effectively denied access to real or personal property of U.S. Airways, the orders qualify under the civil authority provision of the policy. The court went even further, though. It said that the ground stop order issued by the FAA closing the nation's airspace clearly denied U.S. Airways use of its property and prohibited U.S. Airways from operating its business. And so it allowed those business interruption losses to be covered. And that's the type of decision that you can analogize the reasoning that's made by the court here to make a case for airports in making their COVID-19 business interruption claims. Next slide. Minnesota, we have one case that's been decided in Minnesota. Now, this is Kenneth Seifert. Basically, it's a hair salon / barber, and it made a claim under its insurance policy. And obviously, the claim was denied, so they filed a complaint. Now, what the Minnesota court said was that a loss is not established whenever property cannot be used for its intended purpose. There has to be actual physical contamination of the insured property. But the court simply dismissed the complaint because the insured had failed to plead facts demonstrating his property was contaminated, basically giving the insured the option to go back and amend the complaint. So a lot of these early decisions are just guiding decisions for policyholders in terms of how they need to plead in order to hopefully trigger coverage under their policies. Next slide. Florida. Florida has actually been a pretty tough state on these COVID-19 claims, but the decisions have left some wiggle room. The first one, Maloob versus Greenwich, the policy required direct physical loss or damage. Now, that language is different than physical loss of or damage to. You can see how the policy language makes a big difference. If you have physical loss of language in Florida, you have a pretty good argument that loss of use alone ought to be enough. But in this policy, it was direct physical loss or damage. The complaint was dismissed because the policyholder, which was a restaurant, failed to allege that COVID-19 was physically present on the premises. And again, the court kind of tipped its hat that, hey, go, fix your pleading. Infinity Exhibit versus Lloyd's. Infinity argued that it lost income when it was forced to cancel trade shows as a result of an order mandating closure of all non-essential businesses. The complaint was dismissed. In that case, Infinity did not allege that it could not access its property as a result of the governor's order. So the policy requires you to have loss to your own property. It's difficult. This is a circumstance, again, where Infinity really needed that contingent business interruption coverage, since its own property was not the reason that it wasn't able to continue operations. Next slide. Now, there are different circumstances that airports need to think about, because many airports are in a constant state of development. And this is a real situation that occurred. In May, there was an outbreak at Denver International Airport. A job site affected 14 employees that acquired or became infected with COVID-19. Now, the job site alone included more than 550 workers, and it had to be closed for several days to clean and disinfect. Employees had to quarantine. So there was a pretty significant impact on the schedule and on the cost of the schedule. So the question arises, who pays for the necessary cleaning measure and who pays for the costs associated with delay? Next slide. You may be able to look to your builder's risk policies, and performance bonds also can come into play. So a builder's risk policy can include delayed completion coverage, and that can insure against loss of income or additional expenses such as bond interest and things that you have to pay because of the delay. So definitely look at those. Performance bonds, they secure a contractor's promise to complete the contract in accordance with its terms, but also within the time allotted in the contract. So there may be some coverage under the performance bond. Really important in planning your projects. A lot of these policies contain virus exclusions, and you definitely don't want a virus exclusion in the policy. If you can avoid it, or if you can ask for an endorsement to remove it. Even if you can only obtain 14 days of coverage or 30 days of coverage, obviously a virus situation isn't going to be an incredibly long delay in most cases. So it should be something that the insurance industry is willing to write a product for and accept a premium for. So I would suggest that you talk to your brokers. The other thing to do is to make sure that you shift that liability and the purchasing of insurance obligation onto the contractors or developers, and make them prove to you that they have obtained the coverage that you are requiring and that it does not have a virus exclusion. Really important in terms of all your contracts with vendors, with tenants, with contractors and developers that you're working with, to make sure that that you address insurance issues. Next slide. Environmental policies. Now, interesting, there are policies out there that actually define pollution condition to include virus. Those policies sometimes limit coverage to cleanup or disinfectant costs required by CDC or government order. But there are broad forms out there that actually cover lost rents, cover loss of use of property. The coverage varies pretty widely based on the policy language and jurisdiction, and depending on the size of the insured and its resources. Sometimes you can obtain what's called a manuscript policy, which means it's not a standard form policy. It's basically a policy that's written for you and for your distinct business. Next slide. As an example, and there aren't any decisions that I could find on the environmental policies on COVID yet, but there was a case filed, and it was filed in New York, and this is one to follow: Northwell Health Inc. versus Illinois Union Insurance Company. Their healthcare premises, basically, I think that over 20 hospitals were part of a hospital system, and they had purchased a healthcare premises pollution liability policy that covered costs associated with pollution conditions and facility-borne illness events, including remediation, emergency response, decontamination, and business interruption losses. And the hospitals are seeking business interruption losses under that policy. As an airport, and this is something to look into, you really do want robust pollution insurance. And if you can find a policy or ask your broker to see about a manuscript policy that will broaden the coverage for you, it would be worthwhile. So we'll have to see how that case comes out. Next slide. All right, let's move on to liability policies. I know I'm taking up some time here. So this is a really important issue. Now, all I did was go out and Google, claims against airports and, or lawsuits against airports, and a bunch of different law firm websites come up. And this is one of them that came up. And you can see that they're advertising here. And actually have this article on negligence cases against airports for spread of COVID-19. And they go through a bunch of scenarios and potential claims. So I think we're going to see claims coming in the future, and you want to make sure that your liability policies respond to these, primarily because defending lawsuits is an expensive, can be expensive, and that's why you purchase that liability insurance for defense and indemnity. Next slide. So what types of claims could arise in the context of COVID-19? Well, any one of those websites will tell you that they're looking at claims negligence by employers, so the failure to protect employees against exposure. Negligence by other parties. So for instance, an airport's failure to protect its customers, its clients, the folks that walk through its stores. Also wrongful death, premises liability, product liability if there are flawed test kits or face masks sold on site, things like that. So they can come up in a variety of different contexts. Next slide. What does liability coverage protect? Basically, it will insure you against liability for bodily injury arising out of an occurrence. And an occurrence is considered to be an accident. It can also insure you against property damage arising out of an accident. And this is an interesting coverage, personal and advertising injury, because people don't typically think about that in terms of COVID-19. But there is protection for detention or imprisonment, wrongful eviction, libel, slander, and disparagement of goods and services. So let's put this in the context of maybe an example. If you have, airports have been really proactive in terms of trying to improve passenger confidence again, trying to overcome the fear of COVID-19 by adopting new safety measures, by making sure that they conform to CDC guidelines and to the FAA's suggestions in terms of what can be done. But some have gone the extra mile and have actually come up with where they have thermal imagery. They have cameras that can read the temperature of people that walk through the airport. Some can even take temperatures. Some airports are putting in testing facilities right at the airport. So anytime you're proactive and you take a measure, you need to consider the potential liability of that measure. So take, for instance, the temperature reading cameras. Let's say that it catches an individual walking through the airport and it measures them at 103-degree fever. Now, all signs point to a secondary look at that passenger, right? But what if that passenger does not want to have a secondary consult, doesn't want to do anything but proceed to their flight, and you detain them? All right. If it's wrongful detention, if that person doesn't actually have COVID-19 and or isn't a threat to anyone, then you may need to look to your coverage, and you may be able to wedge this into the detention or imprisonment section of your policy. If you expel that passenger from the airport because you are concerned that they are very likely to have COVID-19, and they turn out not to have COVID-19, could you potentially make a claim under your wrongful eviction coverage, or is that potentially covered under your liability policy? So those are both important. Now, what if that passenger, you don't detain them or expel them, and they continue on, and it turns out they do have COVID-19, and the people that they come into contact with become infected on your premises? Well, you didn't warn those other passengers. So could there be a negligence case against you? Yes, there could. And that's when the bodily injury arising out of an occurrence coverage would come into play. So those are really important things. What if you did warn the passengers in the terminal that that individual was walking through, that this person has a high likelihood of having COVID-19 because they have 103 fever and they're wheezing. Well, and it turns out the passenger doesn't have COVID-19. Well, then you have just disparaged them or slandered them, or so those things can trigger coverage, but you really need to think about the responses to those things. And one thing in terms of careful planning is, I'd say, stick to your proactive nature of trying to do the things that need to be done to make people feel safe to fly again, because the industry depends on it. But do what you can to prepare contracts to outsource those things to, say, third-party vendors. If you're going to administer tests at the airport, allow a contractor, someone else, to come in and take the liability and the responsibility for those things, and make sure that they have the insurance to cover those things. Next slide. I'm just going to go over. I think I have some more examples here. Oh, let's go back one more. Sorry, I didn't cover workers' comp yet. So I think we're going to cover just a couple more examples at the end of the slide on things that are being done at airports right now that could result in liability. But there are things to think about and to talk to people like Dan and Lauren about, because they write these contracts, and make sure that you are able to shift these liabilities by outsourcing some of the safety measures that you want to take. Medical payments coverage, it's just that. It covers medical bills. I haven't seen that really utilized in the COVID-19 context. I think most people have been relying primarily on their own health insurance. The last thing to note, and it's very important again, is the exclusions. You not only have virus exclusions in some of these policies, which we certainly want to eliminate if possible, but you also have, and I think Marty alluded to this earlier, expected or intended acts exclusions. Now, this may come into play if you actually measure someone, for instance, with 103-degree fever. You would expect that they would be infected with COVID-19. And then if you allow them to proceed through the terminal where other passengers are, I mean, depending on what their symptoms are, could the insurance company argue that you expected the harm, or you expected the occurrence? They could argue that. So it's important to think about making sure that you are taking actions that if you do have an expectation, that you address the expectation. Now we can go to the next slide, Molly. Claims by employees. Workers' compensation, very, very critical, important insurance to have in these contexts. While to date, most workers are just submitting claims to their own health insurance because they don't know whether they got it on the job site or somewhere else, there is a subset of workers, especially essential workers, that have a much higher likelihood that they could contract the virus on the job. And if the disease arose out of and in the course of employment, workers' compensation insurance may provide coverage. This is important because workers' compensation also goes hand in hand with immunity for employers. So for instance, in Florida, our workers' compensation immunity is incredibly robust. If a worker believes that they got COVID-19 on the job, they should submit the claim through workers' compensation insurance, and the employer should be immune from liability for that event. I mean, we have that strong public policy in place to protect employers and to make sure that their employees are taken care of in the event that they're injured on a job. Some states recognize a presumption of coverage for workers with high-risk jobs, people that work in hospitals, for instance. But at least one state, and this is California, has expanded that presumption to all essential workers. So in California, your airport employees should fit well within that wedge of workers' compensation. So that's something to consider. Next slide. Airport liability, this is what I was alluding to earlier. Responsible steps being taken now could lead to liability later. When we talked about testing, and what if you have a false negative? you read literature on COVID-19, and some of them say that, you may be asymptomatic, you may not even test positive when you first contract the virus. What if you administer a test at the airport to someone that has the virus, but it shows up as a negative, and they go and infect, and a day later, and they're visiting their 90-year-old grandmother in a nursing home, and boom, now they're going to file suit against the airport potentially. Well, that's why I'm saying, if you're going to have tests administered on property, and you can do it through a vendor, and put yourself, insulate yourself from that risk, and make sure that vendor is taking responsible steps, and really just voice that obligations and responsibilities onto the vendor through your contract with them. That's a very important thing to do. I think there can be situations where there are false positives also, and so really, or as we talked about earlier, accurate positives where you're unable to detain the person. There are also some. One other type of measure that I've seen recently, I read an article on, is this robot that shoots out ultraviolet light. And it's so intense, and it goes out 6 feet in every direction, and it cleans and sterilizes that area. And I know that at least one airport is testing this technology. The important thing to remember is that the UV light that robot shoots out is not safe for humans. And so the robot itself has a built-in sort of automatic stop gauge on it if a person comes within 6 feet in it. I would just be, as an airport, that's something that would require some careful planning. If you're going to take measures that are that have potential exposure to any customers of the airport, definitely want to take careful planning measures. So I think Lauren is hopefully going to talk about some of those planning measures next. And that's a good segue to her. Thank you.
Thank you, Megan. And I think everybody realizes from listening to you what a great coup it is for our firm to get you and your team to come over and join us. We know we're running late, and we'll have my really right-hand person, Lauren Schwimmer, who's helped me with everything, give some information for you on how the current pandemic and the insurance aspects relate to some of your basic airport documentation. So Lauren, the floor is yours. Lauren, you might be on mute.
From the May 29th. Oh.
You just got on again, Lauren. Why don't you start from the beginning?
Sorry about that.
No problem.
Okay. Hi, everyone. Not to bore you, what in front of you on this first slide is from the FAA, the May 29th updated information for airport sponsors considering COVID-19 restrictions or accommodations. And it was a long document. Those are two of the pertinent portions of it dealing with health screenings. And it is acceptable as long as passengers are not being categorically refused access to air transportation. And airlines may refuse transportation to passengers because of viruses and diseases. It's really the airline's decision. But as it specifically says, and then in the next part is what can you use your airport revenue to do in that regard as to health screenings. And the FAA considers the testing and health screenings of airport employees to be legitimate operating costs, as well as certain costs associated with cleaning, extra cleaning, etc. But if you look at the very end, it says the use of airport employees for public health screening is generally not considered to be a proper use of airport revenue. And airports with specific questions regarding allowable costs should, of course, contact their airport district office. Next slide. You would think that it was the end of it, and that's the end of the question. However, we are still waiting for guidance from the FAA on whether airports can use revenue to pay for the health monitoring of passengers. This issue was teed up by a plan developed by Eastern Iowa Airport in Cedar Rapids. The Iowa Airport actually has a plan for mandatory screening, which is a different issue. And it asked if the FAA could the FAA if it could use CARES Act money in May to cover the extra cost. It's still waiting on that decision. And in a statement released from the FAA recently, it said that it's continuing to review the proposal and that whatever decision it reaches will apply to all 500 of the nation's federally backed airports. I actually just checked the website before this webinar started, and there's still no guidance. However, I do recommend that you check frequently the FAA COVID website because they do have updates all the time. I think December 1st or 2nd was the most recent. Next slide. So what can you do? And I'm actually going to start with the bottom of the slide just to tell you with the response policy that I'm going to talk about that later. Back to the beginning of the slide, one thing you can do is you can impose minimum insurance coverage and indemnity provisions through your minimum standards and rules and regulations. If this was not an online presentation, now is the time that I would ask you to each raise your hand to say whether your airports have minimum standards, and then ask you, those with their hands raised, to keep them raised if they updated them in the last 5 years, or at least looked at them in the last 5 years. And I would bet, and this is from an extremely risk-averse attorney, that there would be very few hands still raised. While minimum standards are not required, the FAA strongly recommends that airport sponsors establish them. Where they are adopted, they have to be applied objectively and uniformly, as otherwise they render the airport sponsor vulnerable to the challenges of prospective aeronautical service providers. Therefore, it's very important that your minimum standards are actually tailor-made for your airport. For instance, it would not be reasonable to require an FBO at an airport to provide jet fuel if no jet aircraft utilize that field. But tying into this presentation, one of the most important items to consider in your minimum insurance coverage and indemnity provisions are what are you going to require as those minimums? And I'm going to just put out a plug here that, as you can see, the Flaster Greenberg Airport team is well versed to help you. And as you can tell from Megan's presentation, she was an expert in helping you figure out those items. However, even when careful planning goes into establishing minimum standards, circumstances may change. I think we can all agree COVID has definitely taught us that. And that is why flexibility is key to establishing and maintaining the relevant minimum standards. It is also key to have periodic reviews of those minimum standards to ensure that they continue to be reasonable. So those whose hands fell down and not seeing them in the last couple of years should really take a look. As to your rules and regulations, you're going to even want those more up to date. And also, it's very important that in every agreement that you do with every lease or contract with any tenant and airline, that you require them to comply with the minimum standards and rules and regulations, or they really don't have an effect. And you're going to also want to make sure, am I still there? Hopefully. I'm still here. I just got to, I just got to notice that my internet's bad. So you're going to also want to make sure that all your contracts are up to date and have insurance requirements, and most importantly, the ability to update those insurance requirements. For example, what is required in insurance has changed a lot over the last 20 years. So it would be a problem if your 20-year ground lease still has the requirements from 20 years ago. Next slide, please. This is a slide of just some of the relevant regulations to consider as to minimum standards. I won't focus there, and I'll go to the next slide since we have some time. So my last point was regarding response policies. And a couple of years ago, I'm sure a lot of you remember when, in connection with IT and data breaches, everyone was coming up with some response policies. I thought they make sense to come up with those kind of policies for COVID. It's not necessarily a legal requirement, but something I think would be very helpful. And on that slide, I show 4 of the key areas. For example, the most important being, I think, the identification of a response team. The team, this should include the description of every name, contact information, role, and responsibilities for the team member. And also, so they know what roles to play and to make sure they're properly trained to perform those roles. And then the next would, you need to have incident handling reporting procedures for if one of your employees gets COVID, or if you find out a passenger. Of course, a lot of that's going to be worked out with the airlines themselves and requirements to report to outside parties. And then after every time, I think it's really important to kind of look back and see what lessons you have learned. And so I want to leave time for some questions. So thank you everyone for your attention. I am really sorry about the internet problems, and I'm going to turn this presentation back to Dan. And I'm sorry, I forgot to slip to the next slide.
Thank you, Lauren. And those internet problems, I think, are universal right now. We've only got 4 minutes left, and an hour and a half is a long time. So let me do one very quick update, and then I'll throw one question that's been asked, and we'll just only take like 2 minutes on it. The update is that with regard to the use of airport funds for testing, again, as Lauren mentioned, we are waiting for guidance on that. I was on an ACI FAA finance seminar last week where they talked about how that guidance should be imminent, not just with regard to the use of airport funds, but also with a concept of just allowing free of charge somebody to come in and use spot on your airport for the purpose of COVID testing and screening. Real quick, in the 3 minutes left, and before I get into that, I just want to thank our people, our marketing people who are spectacular, Krista Egan and Molly O'Leary Grimm, who've put everything together. But the one question that I wanted to get to everybody, and I think Megan, you might get first shot at this, but again, we only have 3 minutes, so we don't want to keep people over, is that one of the questions that's been raised deals with the public use doctrine and the idea that for those airports that have affirmatively said, come, it's safe to fly. Are they in any way violating their obligations under the public use doctrine? And is there any insurance that might cover that? So I'll throw that out to anybody any of the other three panelists who might want to take a stab at that.
Well, Dan, I will tell you that is one of the concerns. The more proactive an airport is in terms of rebuilding confidence of customers and passengers, in terms of saying it's safe to fly, and here, take this test, we do these extra things to make sure it's safe, they do put themselves out a little bit in terms of potential liability. And that's why it's so important to carefully plan for that and to make sure you do not have a virus exclusion in your policies. If you don't, and a claim is made against you, then it's certainly typically going to be bodily injury or personal injury claims. So you would probably be covered for that, but only if you don't have a virus exclusion. So I would definitely look into that, and otherwise work hard to insulate yourself from risk through careful planning, even posting signs at your door saying you warrant that you do not have COVID-19, you don't have a temperature, you don't have this when you take a step into this facility. There are things that can be done to mitigate the public use, I think.
Thank you. And as it's 1:29 and we go to 1:30 instead of asking another question, I know an hour and a half is a long time. So let me thank everybody who presented, Marty, Megan, and Lauren. I want to thank everybody who assisted, especially Molly and Krista. And I want to thank everybody at the Flaster Greenberg team and all of you who stayed with us. Just about everybody stayed with us for the entire hour and a half. So have a great day. Have a great afternoon. For those of you, have a great morning. And we'll see you at the next webinar. Thank you all so much.